The next case on the call of the docket is agenda number 7, number 124753, People ex-rel Department of Human Rights versus Oakridge Nursing and Rehab Center et al., Oakridge Healthcare Center, LLC. Mr. Stavens, please begin.
Thank you, Your Honor. Madam Chief Justice and Your Honors, if it please the court, good morning. Richard Stavens for the appellant, Oakridge Healthcare Center. For 85 years, the appellate court and this court have held that there are 4 and only 4 exceptions to the general rule that the transferee or purchaser of an entity's assets incurs no liabilities for the debts and obligations of the transferor or seller of those assets. That all changed with the decision of the appellate court majority in this case. The majority created a 5th exception for employment discrimination cases. And the majority did so under the guise of radically changing one of the exceptions, the mere continuation exception, and said that the mere continuation exception is now, according to the appellate court, entirely different in an employment discrimination case. The mere continuation exception has always been, as this court said in 1997 in Vernon versus Schuster, that the transferor or seller and the transferee or buyer must have the same management and crucially the same owners. The appellate court in this case changed that to all they have to do is be in the same business. Now, the appellate court really adopted the California rule that the California Supreme Court promulgated in Ray versus Allad. And the appellate court of Illinois and this court in Vernon versus Schuster categorically rejected that concept. The mere continuation exception until this case in the appellate court has always been there must be a continuity of the owner of the ownership of the 2 entities. I would respectfully submit the majority of the appellate court really meant well. They meant to help a seemingly deserving plaintiff, a victim of employment discrimination, and also to bring Illinois into line with the United States Court of Appeals for the 7th Circuit in employment discrimination cases. But I would also respectfully submit that the appellate court got it wrong. I'd like to just take a few minutes to go over the facts and the holding in Vernon versus Schuster by this court. And as far as I think both sides can determine in this case, that is the only case from this court that has addressed specifically the rule and the 4 exceptions. In the appellate court, the cases go back to 1935 and they are legion. And they all say the same thing that this court said in Vernon versus Schuster. In Vernon, the transferor was the father. His name was James Schuster, and he owned a plumbing and heating company. And the transferee was his son, Jerry Schuster. The father installed and warranted a boiler that he installed in the plaintiff's building. The plaintiff, George Vernon, received that warranty. The father then died, and the son became the father's successor in the business. The opinion doesn't say, but it seems to be pretty clear, reading between the lines, that he inherited his father's business. But both entities, the transferor and the transferee, were sole proprietorships. And the court said, well, it's a sole proprietorship and there's no such thing as a separate legal entity of a social proprietorship in Illinois. It's the natural person. And therefore the transfer was from father to son. The father's warranty was then breached. And the plaintiff, who was the recipient of the warranty, sued the son. suing him on the warranty that the father had given. It's remarkably similar to the instant case. You have a transfer. There was an obligation incurred by the transferor. The suit is against the transferee. The significant difference is that in Vernon, the transferor and the transferee were closely related. In fact, you can't be more closely related than to be father and son. That's the closest blood relationship you can have, is parent and child. But it didn't matter. That very close relationship did not create did not fulfill the mere continuation exception. In the instant case, in our case, there's no relationship whatsoever, either by marriage or by blood. The people knew each other. They had been in business together, which is very common when a small business is sold. It's sold to somebody that knows the person or knows the business, but they were in no way related. Now, the chain of events in the courts in Vernon was just like this case. The circuit court dismissed, the appellate court reversed, and the appellate court created a new reading of the mere continuation exception in Vernon, just like the appellate court did in the case at bar. In Vernon, this court reversed. And speaking through then Chief Justice Freeman, this court said, the rule is non-liability of the transferee of assets for the obligations of the transferor, with 4 well-established exceptions. This court cited several of the appellate court cases from Illinois and cited numerous cases from other jurisdictions. And it rejected the appellate court holding the common identity of ownership is only one factor. This court said that there must be a common identity of ownership in order to impose liability under the mere continuation exception. The dissent argued, well, it was merely one factor. The relationship was merely one factor, but the majority, which is the supreme law of the land of Illinois, held no. You have to have an identity of the ownership. And notwithstanding the fact that it was father and son, and it was an inheritance of the business, the court said, no, there was no identity of ownership, therefore no mere continuation. The dissent interestingly said, well, maybe there was also an implied assumption of the obligations of the transferor by the transferee, and the majority said no. Most respectfully, this court should overrule the majority of the appellate court in this case. There should not be a 5th exception or a change in the continuation rule for employment discrimination cases. Very significantly, the United States Supreme Court has never passed on this issue. The appellate court majority relied on 7th Circuit cases, but there is no US Supreme Court case on point. And although predicting what the US Supreme Court will do is not exactly an easy task, I would submit that there's a better than 50-50 chance that when this issue goes to the US Supreme Court, as it will someday, that the US Supreme Court might hold, as I'm arguing now on behalf of my client, that there should only be 4 exceptions, and there should not be a 5th exception created for employment discrimination cases. The irony of that is, if this court now should rule in favor of the state and should affirm the appellate court and create a 5th exception for employment discrimination cases in order to bring Illinois into line with the federal cases, and then the Supreme Court of the United States reverses when it gets one of those cases, we'll have exactly the opposite scenario, that Illinois and the federal rule will not be in line, but they'll not be in line the other way around.
Counsel, can I ask a question, please? Is it fair that employment discrimination claimants in Illinois would be treated differently depending on whether they recover under the Illinois statute or under the federal statute?
It is fair because it's the nature of the federal system, Mr. Justice Burke. It's the nature of the federal system that we have different results in different courts. We have different results in different states. We have different federal law and different state law. If we're talking about fairness, and we just create a fundamental fairness rule, well, then there's lots of plaintiffs whose right to fairness is equal to or greater than an employment discrimination victim. For example, and the appellate court passed on this over the years. For example, victims of catastrophic injury, victims of wrongful death, people who don't recover their wages. Illinois has public policy that all those people should be protected. But if we start creating exceptions for the victim of employment discrimination, the floodgates are going to be open, and all those plaintiffs who have previously been rejected by the appellate court are going to say, me too. And there's going to have to be exception after exception after exception for those people. And pretty soon, the exceptions are going to swallow the rule. So to specifically address your question, it's just the nature of the federal system that there's going to be a different result sometimes in a state court versus in a federal court. Stare decisis is really an important issue in this case. These appellate court cases, as I said, go back to the very beginning of the appellate court as a court of record when its decisions started to have stare decisis effect. We have 85 years of law, and businesses have relied on the fact that there are 4 exceptions and only 4 exceptions to the general rule regarding transfer of assets. Also, the legislature has had all those years to change the rule if they wanted to, and they haven't. Now, the state made an argument in this case that if there were an exception, the parties could accommodate for employment discrimination. The parties could accommodate that in their buy-sell agreement or their transfer agreement, whatever you call it, between the transferor and the transferee. And the state, in effect, is saying, well, the contract should control. But I agree, the contract should control. But if you look at the contract in this case, and it controls, the contract specifically says that the transferee will not incur any of the obligations of the transferor, and it cannot have a judgment entered against it, and it is not taking on any of the liabilities of the transferor. So for all those reasons, I respectfully submit that this court should essentially affirm what it said in Vernon versus Schuster and reverse the appellate court. Now, there's a second basis to the appellate court decision, and that's the fraudulent purpose for escaping liability exception. And the appellate court also relied on that. And that exception is one of the 4 well-established exceptions. If the purpose of the transfer was to enable the transferor to escape liability for its obligations, then the obligation will be imposed upon the transferee. In this case, there is no evidence of fraud. This was a small claim by one person against the transferor. No one gave any thought to Jane Holloway's claim. I don't mean to minimize her claim, but it was the tiniest of little claims there was no debt to Jane Holloway until 27 months after the transfer occurred. This was not a transfer to escape liability to Jane Holloway. She had an incoherent claim. Lots of people make incoherent claims and they go no place. Merely filing a charge does not create a debt. And as the dissent pointed out in the appellate court decision, the amount of Jane Holloway's judgment is essentially equal to 1 month's rent that the transferor owed to the lessor. You're not going to give up your business and transfer out all your assets and go out of business to save 1 month's rent. And that obligation of 1 month's equivalent to 1 month's rent didn't come about, as I said, until 27 months after the transfer. The transferor truly was in financial trouble. And of course, the great irony of this case is that it was because the state of Illinois, the plaintiff in this case, wasn't paying its bills to the nursing home. And the nursing home either couldn't, had a terrible choice. Either it didn't pay its rent or it didn't pay its employees. And of course, if you don't pay employees, they leave. The other intolerable choice was to cut back on medical services to the patients, and that you absolutely cannot do. So they weren't paying their rent, and they were faced with the potential of a forcible entry and detainer action by the landlord. So they did what they didn't want to do. They were in extremis. They were financially failing, and they transferred the assets. I see a light went on, but I don't.
Few minutes to follow up.
A few minutes.
Yes, the red light.
The color of the light from here, Your Honor. Sorry. So the transfer and the transferee were not related. It was as much of an arm's length transaction as this could be between people who were in the nursing home business, and somebody came along and he saw an opportunity to buy something at fire sale prices and did. And that is not fraud. That is just good business. Thank you very much.
Thank you, Mr. Stevens. Mr. Dozeman.
May it please the court. I am Assistant Attorney General Aaron Dozeman. I represent the state in this enforcement action that was brought at the request of the Illinois Department of Human Rights. Human Rights Act violations are a particularly invidious type of harm, not only to individuals, but to society. And that's why Illinois has very robust anti-discrimination policies and administrative oversight. But as we've seen in this case, the enforcement of those judgments can be thwarted by corporate legal fictions, preventing victims from obtaining relief. And this case presents an issue of first impression concerning the enforcement of Human Rights Act violations. And that issue is, what analysis should apply when a company buys the assets of another company, and when can that purchasing company be liable for that predecessor company's Human Rights Act violations? And the analysis that this court should adopt is the successor liability doctrine that has been adopted and used by federal courts to enforce federal labor and employment discrimination statutes. It is the only equitable successor liability doctrine that considers all the relevant interests, and those are the discrimination victims' interests, the values of a free market system in which corporations operate, and Illinois' anti-discrimination policies, which are embedded in the Human Rights Act and the Illinois Constitution. And the purpose of this doctrine, any successor liability doctrine, is that it is the same balancing act. It is protecting creditors from losing their ability to collect due to events that are out of their control, preventing wrongdoers from escaping liability, allowing corporate assets to find their most valuable uses on the market, and shifting losses to parties that are in the best position to absorb the costs of illegal discrimination. But the federal doctrine is the only one that makes room for the enforcement of anti-discrimination policies. It considers whether there is notice of a pending charge against a predecessor, who is in the best position to be able to provide relief, and the continuity between the predecessor and successor's business operations. Adopting the federal successor liability doctrine is a threshold question in this case, and it by no means means that successor liability is imposed in every single case. But this case exemplifies why this doctrine should be adopted, because there was a discrimination charge pending at the time that the company was incurring significant liabilities, and Oakridge Nursing transferred all of its assets in a transaction that lacked negotiations, consideration, and valuations. It was not a bona fide arm's length transaction. Yet these were sophisticated parties with significant experience in the nursing home industry, and their contracts demonstrate how sophisticated they were. And finally, adopting the Human Rights Act, the federal doctrine for Human Rights Act violations, simply puts the Human Rights Act on equal footing as its federal analog, which is the Civil Rights Act.
Can I ask a question? I asked the opposing counsel about fairness. Is it fair that an employment discrimination creditor is afforded a specific avenue of release? I dare say less onerous avenue of relief. I think of the Nguyen case that the dissent cited, where the plaintiff lost both hands to a defective machine and wasn't able to recover under successive corporate liability, as the law exists in Illinois at this time. What is the fairness of allowing employment discrimination claimants to have a specific avenue of relief?
Let me first say that whether to adopt this doctrine cannot simply turn on how sympathetic the plaintiff is. They're all worthy causes. The person who has unpaid wages, the person who suffers a tort. But this case is about enforcing the Human Rights Act. And right now, individuals who pursue their discrimination claims with under state law remedies through the administrative procedures afforded to them, which are free, and opt not to go into federal court or bring state law and federal claims in state court, have less remedies. And this should not be any surprise to prudent business owners who are already subject to Title VII's obligations. And this federal doctrine is no surprise. It's been around for nearly 60 years. And so all this does is put the individual who opts to go through the Illinois Department of Human Rights to enforce perceived discrimination in the same position as someone who obtained an attorney and went to federal court.
Mr. Dozman, Mr. Stavens was talking about contract law. How does that apply here now going forward if we should adopt what you suggest? Wherein parties agree not to have the new owner, be liable for anything.
I think that parties have probably always contracted not to take on liabilities, but it's really about what the common law doctrine, the traditional common law doctrine that this court already recognizes, looks to the substance of transactions. And because it is a common law doctrine, parties aren't simply able to contract out of this potential liability under the four traditional exceptions or under the federal exception. And I equate it a little bit to employee classifications. Maybe employers often contract to classify employees a certain way as independent contractors or employees, but that doesn't always control. The courts look past that contract language to determine what is the actual relationship going on. And because this is an equitable doctrine, the equities control in a case on when to hold a successor liable for those Human Rights Act violations. There are a few. I want to note that the doctrine of stare decisis is inapplicable in this case. This is an issue of first impression. No precedent is rendered invalid or overruled. It is simply an issue of first impression. That is how the doctrine has been adopted over time in federal common law and also in the states who also have adopted this doctrine. The United States Supreme Court has addressed this issue. In fact, this doctrine began with the United States Supreme Court in labor cases in the 60s and 70s. The United States Supreme Court came up with this doctrine, and I can't speculate about what the Supreme Court will do with the doctrine, but this is how common law develops. And I see no indication why this court should not, or is barred, or will in the future run into some problem if the Supreme Court abandons or if Congress does away with this doctrine in federal cases. That says nothing about what Illinois is going to do with successor liability in the Human Rights Act violation context.
Mr. Dozeman, the issue of fraud, is there always going to be a finding of violation of fraud, and in this case particularly? What is the fraud?
In this case, fraud and the federal doctrine overlap. Under the federal doctrine, you don't always need fraud. But here we have the inference of fraud. Fraud is famously difficult to prove based on several considerations. First of all, there was no consideration on page 570 of the common law record. Helen Lasik admitted that there was no consideration for this transaction, and transactions that lack consideration are presumed to be fraudulent or done for escaping liabilities. Secondly, there are several factors that support a fraud in fact finding. We've illustrated them in our brief, and the appellate court also picked up on these factors. And it's due to the fact that there was a pending liability at the time of this asset transfer. There was no consideration, no valuation, no exchange of value. And the debtor is, or the pending discrimination victim is left without any avenue or recourse. And because we're on summary judgment and the state was the non-movement in this case, we are entitled to the facts viewed in a favorable light, and all reasonable inferences drawn from those facts. And this is due to Oakridge Healthcare moving for summary judgment very early in the litigation. I believe it was a few months after the complaint was filed, where we had developed no factual record in this case. And so with such a thin record, there are a lot of unanswered questions, and that is to Oakridge Healthcare's disadvantage, because those gaps, based on the undisputed facts, create the opportunity to infer fraud based on those facts, and they have to be construed in the state's favor in this case. And that's why there's why judgment as a matter of law on the fraud question was not appropriate in this case.
Now, counsel, you said that you urged us, or are urging us, to adopt a fifth exception, and that would be for any Department of Human Rights case. Is that correct?
That's correct. For the enforcement of violations of the Illinois Human Rights Act. So
Okay.
the doctrine attaches to violations of that act.
And it would be whether they were pending or not pending at the time of the transfer.
I believe it would have to, well, because the factors, the critical factor in this analysis is notice. And so there has to be some kind of charge pending. And in federal court, you can go to the Equal Employment Opportunity Commission, the EEOC, and file a charge. In Illinois, you can go to the Department of Human Rights and file a charge. But when a charge is filed, there is constructive notice of a pending liability, and you can't ignore that pending liability. And that seems to be what Oakridge Nursing and Oakridge Healthcare did in this case, is didn't pay any mind to it, either because they thought it was meritless or because they knew they could enter into a transaction to dump any debts or debt-saddled LLCs by creating a new one and transferring the assets.
So
That-
it isn't because the nature of the claim totally, it has to be a pending claim to come within the exception. Is that correct, or am I wrong?
I think you're correct. I've only seen cases finding or imposing successful liability where there is a pending claim at issue. Once there's this known potential obligation, companies can't ignore it. And that's important not only for this individual, but as I've said, there's a societal harm with these Human Rights Act violations. And Illinois takes these very seriously. The Department of Human Rights takes them very seriously. And in this case, the department began investigating that charge when it was filed, as they do all charges, to determine whether there is substantial evidence to go forward with these cases. So yes.
Thank you.
Mr. Dozeman, you've argued there's a lack of consideration. Would you please revisit that and just tell me what the key factor, what you're pointing to that shows no consideration?
On the record, C-570 is the deposition of, I believe, Helen Lasik, and she answers a question, was there consideration? She says no, and that's what she said. And I haven't seen the counsel for Oakridge Healthcare identify any consideration. I'm only going on what the record reveals. It does seem odd that they're admitting that, or that is what the record reveals, but that's what's going on here. There were no negotiations, no valuations. That was the nature of the transaction, and they would like to characterize it as a way to save. They had to save a company that was just going under, but if there are protections afforded to LLCs, but that is not a carte blanche permission to enter into transactions that completely negate any creditors.
Counsel, the dissent noted that at oral argument in the appellate court, you reaffirmed that that the state never argued the fraudulent purposes exception. Do you agree with that observation by the dissent?
Yes, well, I'll put it in this light. The fraudulent purpose exception was not mentioned in our response to summary judgment, correct? I think what the dissent quoted in her decision was based on the trial counsel's oral argument, but in any event, it was no forfeiture, as the appellate court found, and even if there were, it was not an abuse of discretion for the trial court or the appellate court to reach that fraudulent purpose exception. It was Oakridge Healthcare that moved for summary judgment. They argued that fraudulent purpose exception was not met. The circuit court made a finding on the fraudulent purpose exception, and we then challenged that finding on appeal. So to the extent we're talking about forfeiture, we certainly wanted to impose liability under these exceptions, but we were disadvantaged because of the posture we were in, being on our heels on responding to summary judgment so early in the case. The threat that the floodgates of liability might be opened, I can confidently say that I don't believe that will be the case, because it hasn't been the case in the last 60 so decades of that this has been in existence. Many Illinois businesses with 15 or more employees are already subject to Title VII, and it hasn't been it hasn't hurt businesses from entering into transactions before. So there's no evidence for that fear. And the last point I'll make is that Oakridge Healthcare is blaming the state for its late Medicare and Medicaid payments. I think that blame is misguided. The Oakridge Nursing is the company that discriminated against this employee. But all of these companies operate in a business and an industry that is heavily reliant on government assistance in the form of Medicare and Medicaid. And it could equally be the case that they didn't structure their business in a way to accommodate for a situation where the state, as it may be now, but certainly back in 2011, is facing financial troubles and payments are delayed. If the court has no further questions, we ask that this court affirm the judgment of the appellate court. Thank you.
Thank you, Mr. Dozman. Mr. Stavins, rebuttal.
Thank you, Your Honor. First of all, the federal court doctrine in its application to human rights cases, to civil rights cases, in employment discrimination has never been adopted by the U.S. Supreme Court. I think counsel concedes that. The only labor cases are non-civil rights cases. They're labor law cases. Sometimes the statute even provides for the successor's liability, as pointed out in the briefs, the Warren Act, W-A-R-N Act. The balancing act in this body of law is between the right of a victim to be compensated versus the necessity of making it possible for a failing company to sell its assets and have the business continue with a new owner running that business, have the same employees, make the same product. In the California system, it's very difficult for the failing business to sell the assets to a new owner and have the business continue, because it takes on, no matter what it does, it takes on the asset, it takes on the liabilities of the seller. The balancing act between those competing forces, the appellate court has repeatedly said, is served by the rule with the 4 exceptions that have been the law in Illinois for 85 years. Next point, there was only a charge pending. There was no judgment pending. This was a bona fide transaction. This was absolutely not done to escape the liability of one little charge that was made. That's what it needs to be fraud. It needs to be that they were trying to escape liability of this particular plaintiff's charge. There was no attempt to do that. This was a failing business, not a fraudulent attempt to escape one little charge. It is unfair to allow employment discrimination victims to have an exception, but not to allow the victims of personal injury, wrongful death, even in Vernon versus Schuster, breach of a warranty of a boiler, the sellers and vendors of product and services to the transferor. None of those folks are compensated out of the funds of the transferee under the 4 exceptions. They're all worthy plaintiffs. And if there's going to be an exception for the victim of employment discrimination, there is going to be a request for a exception for each of those people. And it'll be very difficult to resist those worthy requests. And the exceptions will begin to swallow the rule. This rule of non-liability is a rule of contract law and corporate law. It's not a rule of tort law. Businesses have been bought and sold in Illinois for decades based upon this rule with its 4 exceptions. And once we start making more and more exceptions, it's not going to work. The stare decisis here is really clear. It's Vernon versus Schuster. If you read the opinion, it's clear that there is a rule and there are 4 exceptions only. Now, the fraud here that is alleged is some vague idea because the lady who is not a lawyer said there was no consideration. Well, there was certainly legal consideration. The mutual promises and the bailing out of this business by the buyer is a consideration. It got the seller off the hook. And that is a valid consideration. She's a layperson when she talks about no consideration. The fraud argument was forfeited by the state. It never raised the argument in its response to the motion for summary judgment, as counsel has just properly conceded. The majority said, well, they raised it in the complaint. Well, as your honors well know, you cannot oppose summary judgment with your complaint. I mean, that's well established. The majority thought that the transferee had anticipatorily raised that in the motion for summary judgment. But again, the state never picked up on that argument and never argued that there was fraud. And then finally, the majority gave well, to achieve a just result, we'll overlook the waiver, now called forfeiture. And as this court said in Jackson versus Board of Election Commissioners, a just result is not a catch-all for an unfettered authority to consider forfeited issues at will. And then finally, the argument that is made that, well, the state needed a little more time to respond because the motion was made early on in the proceeding. Rule 191B is very clear. If you need more time to oppose a motion for summary judgment, you file an affidavit stating that and you say what you need. And if you can't get it, you can even use documents to oppose a motion for summary judgment. But you can't just come along and say later, oops, you shouldn't have filed this motion so early on. And for all these reasons, I respectfully request that this honorable court reverse the appellate court and reinstate the judgment of the Circuit Court of Cook County. Thank you very much.
Thank you. Case number 124753, People versus Department of Human Rights versus Oakridge Nursing and Rehab Center, known as agenda number 7, will be taken under advisement. Mr. Stavens and Mr. Dozman, thank you for your oral arguments this morning. Mr. Marshall, the Supreme Court stands adjourned until tomorrow morning at 9 a.m., May 14th.
Supreme Court stands adjourned until tomorrow morning, May 14th, 2020 at 9 a.m.
Thank you.